Definition of a property manager. Real estate licensees, both sales agents and brokers, in Arizona have the luxury of offering many different types of real estate services. The specialties Arizona identifies are for cemetery and campgrounds. All other activities a real estate licensee can be involved with are covered under the salesperson or broker's license. That means a licensee could sell residential real estate, lease commercial properties, manage an apartment building, sell vacant land, and lease an industrial building. While given the latitude to offer various types of services, the Arizona Department of Real Estate, ADRA, requires within the Commissioner's rules that a licensee works within their area of expertise and/or competence. This is found in the Commissioner's Rule R4281101 H, which reads, "The services that a salesperson or broker provides to a client or a customer shall conform to the standards of practice and competence recognized in the professional community for the specific real estate discipline in which the salesperson or broker engages. A salesperson or broker shall not undertake to provide professional services concerning a type of property or service that is outside the salesperson's or broker's field of competence, without engaging the assistance of a person who is competent to provide those services, unless the salesperson's or broker's lack of expertise is first disclosed to the client in writing, and the client subsequently employs the salesperson or broker." Staying within one's field of competence describes both the geographical area in which the licensee works as well as the type of service. Thus, a residential agent in Tucson who has a client who wants to rent an industrial building should refer this client to a licensee who understands commercial real estate. By the same logic, if this agent has a client who wants to buy a house for investment in Flagstaff, he should refer that person to an agent who is familiar with that market. Why would a broker be concerned if her licensees are conducting property management without realizing it? There is a simple yet important answer to that question. The Arizona statutes and the Arizona Residential Landlord and Tenant Act require that when managing property, a licensee will have the landlord sign a property management agreement. The rules for a property management agreement are in ARS 32-173. If a licensee does not realize that they are acting as a property manager, it is unlikely they have executed a property management agreement, which is a statutory requirement. Thus, the licensee is violating the Arizona statutes, putting both the licensee and the broker in jeopardy. 2-2173. Property management agreements, contents, termination. Property management firm shall write property management agreements in clear, unambiguous language, and property management agreements should include: state all material terms and conditions of the property management firm's services, obligations, duties, and responsibilities to the property owner. Be signed by the property owner or his agent and the property management firm's designated broker or the broker's authorized real estate licensee. Specify a beginning and an ending date. Contain cancellation provisions that are agreeable to both parties. Provide for the manner of disposition of all monies collected by the property management firm, including any tenant deposits. Specify the type and frequency of status reports to the owner. State the amount and purpose of monies the property management firm holds as an operating reserve for emergency and other purposes. Provide for the disposition and allocation of interest earned on trust account monies. State the terms and conditions of compensation. The property owner pays for services pursuant to the property management agreement. Not be assigned to another licensee or licensed entity without the express written consent of the property owner. May A. Contain an automatic renewal provision. If the property management firm sends the owner a reminder notice at least 30 days before the renewal date, the notice does not negate any other cancellation term otherwise agreed to. B. Provide for reasonable liquidated damages or cancellation fees for early termination of the agreement. C. Allow the property management firm's broker to authorize a licensed or unlicensed person in the direct employment of the broker, pursuant to Section 32-2174, subsection C, to transfer monies from or to be a signatory on a property management trust account to which the property management firm deposits the owner's monies. D. require more than one signature on checks written from a property management account. E. Contain any other provisions that are agreed to between the property management firm and the owner and that are not in conflict with the requirements of this chapter. B. Immediately on termination of a property management agreement, the property management firm shall provide the owner with 1. All originals or other copies of all rental agreements or related documents in the property management firm's possession for current and previous tenants. These documents shall include any applications, property inventories, leases, pet permits, default notices, lease amendments, or addenda in the property management firm's possession. The broker is not required to keep copies of residential rental lease agreements or related rental lease documents after the termination of the property management agreement. 2. All building plans, environmental studies, conditions, covenants and restrictions, inspection reports, contracts, keys, warranties, personal property, or other documents in the possession of the property management firm. C. On termination of the property management agreement, the property management firm shall provide the owner with a final accounting of the property's financial status that includes at a minimum 1. Within 5 days, a list of all tenant security obligations. 2. Within 35 days, reimbursement for all monies remaining in the property accounts maintained by the property management firm, except for monies needed for unpaid obligations incurred during the term of the property management agreement. 3. Within 75 days, a final accounts receivable and payable list. 4. Within 75 days, a final bank accounts reconciliation. D. If there is an on-site management office and any of the records or documents described in subsection B of this section are located on-site, the property management firm may leave the items there for the benefit of the owner on termination of the property management agreement. The property management firm shall inform the owner in writing immediately as to the location of these records. Arizona has seen a major shift in the residential market over the past few years. The impact of predatory lending and overbuilding during 2005-2007 has led to an extremely large rental market. Many owners who bought the American dream in those years ended up short-selling the house or losing the house after a default. Those former owners became renters and will be for several years. At the same time, individual investors came to Phoenix and bought one rental property, along with the institutional investor who bought 150 homes in bulk from a bank, formed a property management company, hired a broker, and put tenants in all the houses. That has resulted in many real estate agents making the jump to leasing, and either knowingly or by default, into property management. This instructional course will help you identify the specifics of property management and demonstrate how to conduct your business within the statutory and regulatory guidelines, thus assisting the clients in their goal as well as increase your income. One natural area that probably does not go beyond an agent's area of competence is when a residential resale agent decides to assist a client in finding a house to rent, or an owner finds a tenant for the condo they own. Since many of the listing forms are interchangeable, many agents easily assist their clients in those activities. This is where many agents and brokers get into trouble. The leasing activity turns into property management, yet neither the agent nor the broker realizes that the agent is acting as a property manager. Yes, within the Arizona Revised Statutes, ARS, are various definitions of and rules for licensees acting as property managers. Chapter 20 of Title 32 of the Arizona Revised Statutes, ARS, is the section titled Real Estate. The definition of property management is in Article 3.1 of Chapter 20. Property management can be defined as a person or entity that acts on behalf of a landlord, offering services to a tenant during their tenancy in a property. We will deal primarily with residential property management issues in this course, and not commercial or industrial properties. In many cases, a broker decides to open and operate a firm that solely does property management and offers no other real estate services. That is a business decision, and every licensee within that brokerage would be made to understand that they may conduct listing, leasing, and property management only. That generally makes it simpler for the broker to manage, since the broker knows that every licensee within the firm is acting as a property manager. More common, however, is the residential real estate brokerage firm that does residential sales and listings and allows the licensees within the firm to conduct property management. This is the type of firm where the broker and the licensee often get into trouble since many of the licensees conduct property management activities, yet do not realize they are acting as a property manager. When challenged by the broker, or worse, ADRA, they state, "But I am not a property manager." Property management is a specific line of business that many brokers throughout Arizona do not offer, and these brokers prevent their licensees from offering such services. The brokers that allow and conduct property management generally will have strict guidelines for the agents that conduct property management and often will have the agent sign an agreement outlining the rules, landlord-tenant, Arizona statutes, and the broker policies that affect property managers. The answer is no. Property management has some rules, yet there is no requirement as to which bills the manager pays and which bills the owner pays. When an agreement is established, those terms are negotiable.